before payola was banned in the state, people were paying DJs.
Can you enforce your neighboring rights?
How does that impact mechanical rights?
Neighboring right is associated with whatever you create. Hello. Welcome back to IP Zone with Bnoskka. I'm telling you, it's going to be a wonderful session. And this is a session we're going to discuss what is mechanical rights and neighboring rights. And before I continue, this is brought to you by Uprise Music. Uprise Music does distribution and publishing. And if you want to publish your music, if you want to distribute on digital platforms, the place to go is to visit Uprise Music. And today I have some wonderful guests in the house, and I want to introduce them. Let's start with the lady on my right.
Hi guys, my name is Margaret Doe, but I prefer you all to call me Megs. I'm a recording artist and a social media influencer.
All right, and then to my left.
My name is Philip Nguyen. I'm a content creator.
All right, so these are Megs and Philip. Welcome to Bnoskka IP Zone. Right, so today, like I said earlier, we're discussing mechanical rights. And I'm just going to say what is mechanical rights, and in the form of trying to explain what constitutes mechanical right. So if it's about literary work, if it's about musical work, if it's about sound recording, video, sculpture, paintings and drawings, computer software programs, all these copyright eligible materials, there are machines that helps you to produce them, okay? And once you have been able to produce the first original version, how do you then reproduce again? That right to reproduce again is what we call mechanical right. Now, let's take, for example, if you make a music, you will need a microphone. Originally, you don't even need a microphone, but you can just create the music in your head, and then you can still sell it, right? And then you can do a performance about it. But if you want to go on a stage, you will need microphone, you will need mixers, you will need tape recorders, you will need all that. That would influence your music. And so therefore, if anybody has to also do the same thing, the person needs to have mechanical rights, which is the right of reproduction. And that right resides or is assigned to the author only, or the authors. Now, so therefore, sometimes somebody can ask, but why is it that if I buy a car and I get to the port, either the airport or the somebody will say water port, the harbor, they charge blank levy on it. Why do they charge blank levy? Yes, they charge blank levy because the microphone, the laptop, the CD, the pen drive, and all those cameras and the headphones and all those devices have the ability to reproduce somebody's work. Songs will be played on it. That's reproduction. That's performance. And now the reason is that if you wanted the song, you needed to invite the artist for the artist to perform for you to hear. And because the artist is not there, therefore that machine is also reproducing. That's why they charge blank levy on it to be given to the artist. So mechanical right literally means that rights of reproduction. And I want to read how the copyright law defines mechanical rights. So if you go to section 76 under interpretations, section 76 of the Copyright Act 2005 Act 690, it says that mechanical right means the right of the author to reproduce literary, dramatic, musical works in the form of sound recording and audiovisual works produced mechanically and includes electronic, acoustic, electric procedures, the rights of which are usually administered by the authors or societies and any other appropriate organization. So the right to be able to reproduce, to do all these things is what we mean by the mechanical right. And so therefore, if you don't have the mechanical right, you cannot pick anybody's material and reproduce it yourself. And so this is what we mean by mechanical right. Now let's look at neighboring right. And the neighboring is like neighbor, the word neighbor, so neighboring right. Under copyright, if you create any material, create any work, whether it's a picture, it's a video, it's an audio recording or musical work, or dance, which is choreographic, and then any form. Now, that work you have created, you have two basic rights. Your moral right, which is your name, and then the economic right. But that economic right, the first one you can think about is performance. You'll be invited to a wedding, you go and sing, you'll be invited to a national theater or any activity, and then you charge for it. But let's assume that you will not be there. Now you have it in audio, you have it in video, you have it in a picture, and somebody is also going to use your work in another form without you being there. And that right is associated with the economic right, and that's what we mean by neighboring. So let's assume that when your song is played on radio, it's a neighboring right. You are supposed to get money from it. If your song is played on TV, it's a neighboring right. It's part of your right as a copyright owner. The money must come to you. Money must come to you. Or your song is performed on an occasion where you are not there. Money must be paid to you. Okay? So all those put together, we call it neighboring rights because they are right associated with it, with your work. Let's take, for example, a company is doing an advert and then they decide to play your song for their adverts. They have to pay you because it's your right. Okay? If they have to invite you to come and perform, I'm sure you would charge. Even if you want to go for free to go and perform, that is your right. It is only you that have the right to perform it. But once they are performing it without you, then it's a neighboring right. They have to pay you. They have to pay what is due you. And so therefore, if let's assume that your music or your picture features in somebody's video, somebody's making a video and then your video also appears in it. Sometimes I see it on Facebook and people say, we don't own rights to this. They say a disclaimer, I don't own the right in this video. And no. Whether you put a disclaimer there or not, if the person takes you to court that you have not paid any money to him or he has not authorized you to use it, the court will listen to the person, okay, because it's a neighboring right. It is their right to get the economic right from it. So if nothing is coming from them and you are saying that you have put a disclaimer, the law only says that for the purpose of news, the purpose of entertainment, and you have not registered a company that you are a news broadcaster. I've seen a lot of people on Facebook also, this is news. You have no company, you have no business that shows that you are a registered entity and therefore you have the right to grant news. Once you do that, you are infringing on people's rights. And so therefore you must understand that whoever that made that song or that video, that picture must also leave. Now there is even one issue where I heard an artist or somebody, a very beautiful lady was dressed in the Ghanaian kente cloth, and then she holds some beautiful calabash and they took a picture and they wrote on top, "Welcome to Ghana." And that's about 15, 20 years ago. And the lady has grown up and she said she didn't even get one cedi out of that. But you walk in town, you meet traffic lights, people have printed the picture. In fact, these days they've even enhanced the picture, lovely. Put so many nice designs on it and they say, "Welcome to Ghana, we are selling 150 Ghana cedis." When the person in the picture is not getting anything, what do you think? It's a neighboring right. The person must get money. After all, if he had not been designed and to take that picture, would you have gotten that picture to stand in traffic light and then be selling? It's not possible. So we all have to understand that neighboring right is associated with whatever you create. Now, one of such neighboring rights is that you have taken a picture. You have not authorized anybody. And then they take that your picture and design a t-shirt and they are selling the t-shirt. One, the t-shirt is not for you. You did not authorize them to use your picture. And they are using your picture and designing t-shirt and selling. That is wrong. It's a neighboring right. It is a right that you alone should be able to do that. And so therefore, before they can do that, they need to ask permission from you so that you can also get some money. You see, copyright law is a business. It's an investment. Once you're able to create something, it's supposed to benefit you for your lifetime and also 70 years after your death. So it's like it is a property to your children, your children's or your grandchildren, or whoever that you chooses to be your benefactor, okay? Or it's your estate. So it's your property. So you can even write it in your will. You should write it in your will that this my song, when I die, the royalties should go to this person. This my video I made here, the royalties should go to this person. You should be able to do that. And that is what we mean by neighboring right. So if it appears in a movie, we call it synchronization. It has synchronized in somebody's video or movie. And so therefore you must get money from it. We're here in Ghana when an artist, I think, I've forgotten his name. There was one movie that was shot in Hollywood and his song appeared in it. He was so happy. He said, I've gotten money. Why? Because his works has synchronized in it and it is neighboring right. In fact, they need to pay and they will surely pay. We were here when Bravo sued Drake in US for using 5 seconds or 10 seconds or 15 seconds of his work in a music where he has not gotten permission. And there's lots of neighboring right issues. I mean, you cannot use anybody's work when you don't have right over it because it is their neighboring right. It is part of the right they owe in the copyright. It is not only against production, it is not only against performance, but if you pick the material and you use it in any other form without permission from the author, it's a neighboring right. It's part of the right they owe in the work. And so therefore, people should understand. And so if you are watching me, you are listening to me, before you pick somebody's work and you want to transform it to do something else, think of neighboring right. The person has got a right in it. And if you don't want to face any legal action, make sure you have got a written permission. I mean a written, not just a verbal, because the person might change his mind. But if it's a written permission and there are witnesses to show, then it means anytime cases arise out of court, you can be able to produce that document to say that indeed I had gotten authorization before I did this work. So don't make the mistake before you want to go and correct it. Some people will say, oh, I want to do a cover version of Kwame Eugene's song, or Burna Boy, or Stone Boy, or Shatawale, or whatever, Kofi Kenata, or Patience Nyako. Then you finish the cover version. Then now you are chasing them to give you authorization. No, you have wasted your money. If they don't give you authorization, you can never release it. If you dare do, I'm telling you, this is Bnoskka, you will face the legal consequences. If the person does not listen to you, if he doesn't mind you, it is free. Now, I want to chip in some aspect of what we call look-alike. It is part of the neighboring right. Now, imagine you were born and you look like Kwame Eugene, or you look like Shatawale, or you look like Sarkodie, or you look like Stone Boy, or Burna Boy, or Wizkid, or what, Davido, or Ed Sheeran. You can look like anybody in the world, okay? That is okay. As part of their neighboring rights, you cannot use the fact that you look like them, we call it look-alike, and then begin to perform their songs in their name. It is wrong. As their neighboring right, you don't have that permission. You don't have that authorization. The fact that you look like them or you can sing like the person, you don't have the right to do that because it is their neighboring right. It is only them that have the power to be able to perform their songs. So if you look like them, it's okay. There's nothing wrong with it. Sometimes there is even a research which has been published. The title of the research is called Celebrity Worship Syndrome. Okay? People try to imitate how celebrities dress. They make up themselves, cut their hairstyle, or make their hairstyle or hairdo to fit like that celebrity. It's okay. But the moment you want to use that same looks or look alike to sing their songs, perform it at programs or whatever, I'm telling you, if they take you to court, you will face the legal consequences for that. So we should try and avoid that, because it is their neighboring right. It is their right that is encumbrance in the protected works they have be able to create it. So this is Bnoskka IP Zone. Let me come to my guests in the studio to ask for their contributions, questions, and remarks. But if you are watching, try and subscribe, share this video, and let us know your comments. Please write your comments so that we can be able to understand your needs. And if there's something that you think we have not addressed, you can also write it, and we would surely listen and then get back to you. All right, so let me come back to the studio. Who will start first? This is episode number 18, right? Yeah, so we going. Oh, let me hear ladies first or gentlemen first.
Let me ask. I have two questions.
Okay, do.
In terms of neighboring rights,
Yep.
I understand, there are instances where in music, an artist, to take your music to a TV station, you pay them to play it. Let's say 2 months, so you pay for 2 months. And then the song becomes so good, and 3 months, now they start playing it by themselves without you paying it. Something like this, can you enforce your neighboring rights? Because the duration with which you paid for is sort of done, and now they are capitalizing on it. And also, the second question, at what point do you use strong legal action in sort of cooping royalties for a right? And at what point do you use an organization?
Okay. All right. Thank you very much. The first question about promotion. By law, radio, television, or any station that performs your work, whether you have paid them or not, they are supposed to pay royalties. And so in the US, when the word payola came, they banned it way back in 1976. They banned payola. Payola simply means that pay your way out. Okay? By radio and television, they are supposed to produce content. And so when they think that your song is good and they have to play, they play. And the moment they play, they have to log and pay money to the collective management organization for the performing that work. Now, the law says that before payola was banned in the state, people were paying DJs to repeat their song so many times on radio. And music is such that the more you listen to is the more that gingers you, is the more that gets into you and you would want to listen again. So when that happens, then it means people are getting more advantaged. So DJs were getting money and the station owners of the radio stations were not making money. So they ban it officially in the United States and all over the world. If you are seen collecting money from an artist to play a song, you are in trouble. Because the more you play the song, is the more the station is going to pay money, royalties for the artist. So what they've tried to do is that they have come out with what we call a rate card. This rate card simply means that if we will play your song for 1 month, we will charge you $6,000 or 6,000 naira or 6,000 Ghana cedis. And they know that 6,000, if they play it 10 times, they are going to pay a percentage of that money to the collective management organization. So they've done all the calculations. So if you have contracted them and you've paid the money and after that they are playing your work, there is nothing you can do. If you want your work to be stopped to be played, then it means all you need to do is to go to court and say that this work, I've changed my mind. I don't want it to be played again. It should be withdrawn from all systems. But don't forget that it's a contract. So the Ghana Contract Act 993 also comes into play. So whatever agreement you have had with somebody before you made your change of mind does not affect it. So that contract must be executed. It must expire before your declaration will take effect. So if they are playing beyond the time you pay them, it's okay. They will still pay royalties for you. And I'm sure you should rather be happy instead of thinking of stopping them. But if for any reason you think you want to stop them from using your work, why not? You have every right to go to court. This one, you cannot walk into the station and demand that they stop. No, it is only a court order that can grant that injunction. So you apply to the court, you pay money, and then they will listen to your case and give the justification why you want them to stop playing it. Then it will be heard. On the second aspect of at which point do you enforce your right through your right of collecting royalties through you personally or through a collective management organization. Now, by law, an artist would not be able to go round to every radio station and be going to collect money. I heard you played my song yesterday, so give me the money. I'm here. No, the law says that there should be a registered company which is licensed by Copyright Office with a license we call Collective Management Organization, for short CMO, or Performance Rights Organization, PRO. If you go to London or UK, that's what they call it. So now, the Performance Royalty Rights Organization or Collective Management Organization, they are the only institution mandated by law to be able to go and task radio stations, events, places, churches, mosque, anywhere that music is performed, including the stadia and everywhere, in the buses, in the aeroplane, in the taxis, wherever your music is played, they are the only people are supposed to go and collect money for you. But if you have assigned your right to them, that is when you can take the collective management organization to court, that I have assigned my right to you to collect royalties for me. Why am I not getting money when people are playing my song on radio? Then the court will now listen to your case, prove the document you sign with the collective management organization to show that you are indeed a member, and why they are not paying royalties for you. The court will then ask them to do the needful, and that is what it means by that. But beyond that, an individual cannot go on the street or to any place and demand that you have played my work, I need money. The law does not permit that. Right.
Right.
So, Bnoskka, my question is that with advancement in technology,
Yeah.
how can we now manage?
How does that impact mechanical rights and labeling rights with the new introduction of the AI and the blockchain technology?
Now, with advancement of technology, I remember 2012, 2011, I went to Nigeria when I was doing my master's, to find out how they collect royalties. And I found out that at that time, they had employed, and that's about 2008, 2007, thereabout. They had employed NSS, they call it National Service, NSS, NYPD. They've employed 250 in Lagos. They sit down with radio, small radio, and a headphone. They are listening. If a radio station plays a music, they write the name of the song, and then they will log. Then they wait. They finish at 7:45. Then they write 7:45. Then you have to calculate how many minutes did they play. You say total 3 minutes 15 seconds. Yes, they were doing that. But with the advancement of technology, these days all you need to do is just buy the software. Download the software and put it on your FM station and get a little computer. You to be able to log onto every song that is played. I'm sure there's even one app somebody has created called Shazam. Once you play any song anywhere, once it's on the digital stores, Shazam will just listen with your microphone on your mobile phone and will say, oh, this song is from Max, or this song is from Philip Nwang. And that's technology. Now, with the issue of artificial intelligence, these days, you can even tell an artificial intelligence app system to create a song for you by giving it the words or even suggesting the melody, and the rest will be done automatically, because artificial intelligence systems have learned human way of life, human way of living, and therefore those algorithms have been put in place to be able to understand how you would wish to create a happy song or a sad song or a funeral song or a wedding song or birthday song or whatever. And once that is done, once you create it, the artificial intelligence was created by somebody through a computer software code, which is also copyright. And their right is that once you want to sign to use the artificial intelligence as part of their terms and conditions, you must agree that you are a third-party user, and therefore they have a right in whatever you use the app for. So we are yet to find out how, when these things become commercially big viable, be able to know how they will share royalties and split. But for now, I have no idea. I hope to see what will become of that in the future. And the issue of blockchain is also now trying to revolutionize, even these days, how royalties are paid. Sometimes you know that you go on a system, a bank transfer, they will take some charges. Blockchain will be able to give you another means through where your royalties can be paid through one system, maybe in Jamaica, and then all of a sudden the money can come through without any kind of intermediary charges and all that. And I'm sure it's an avenue people can also research into it to help us with our neighboring right in terms of how we collect royalties. Any other question from the audience too?
The process of
collecting mechanical rights.
Yeah.
Isn't different for a solo artist, an independent artist and an
established artist.
Okay. If I understand established artists, meaning like somebody like Burna Boy, Shatawale, Stonebwoy, Kofi Kinata, like that. Oh, it is no difference. It is just that the artist has to decide, I want royalties. So therefore, you have to assign your right to a collective media organization or a performance rights organization, like I said in UK. Once you do that, it means money will be collected and then be given to you. But if you don't assign your right to any organization, yes, they will still go ahead and collect royalties on your behalf. The law says that they should put that money into what we call black box. And the money will be there, but it will not be there forever for you. At a point in time, the law says that after 5 years, 10 years, they should take the money and redistribute it to the people who are already in the system, even though it's not for them. So it is to your disadvantage. But as an individual, like I said, you cannot be going around to be collecting royalties. It is only established organizations that can do. Yes, let me listen to you.
How does an emerging artist take advantage of the gains of copyright? Because we are seeing in our landscape that it is tougher for emerging artists to get into mainstream. I'll make an example with Ghana, a country I've always visited.
Okay.
I was telling my cousin that we have had 5 stars for almost 2 decades. That's in the case of Nigeria. Now, if you talk about popping artists, sometimes you forget Whiskey. We know that it's really great, but right now, it doesn't have a song that's popping. But in Ghana, that's not the case. If Sarkodie leaves for 4 years and he comes back, he gets to number 1. So how can copyright, sort of make emerging artists get to mainstream?
Thank you very much. Right, that's a fantastic question and a big one. Right. Now, as an emerging artist, what I would want you to understand is that everything you create, whether music, movie, picture, or whatever, it is your right and it is your intellectual property. It means it's the creativity of your mind, which is a property like your car, your house, and everything. It is up to you to want to fight whoever that use it without getting you money, and it's up to you to let it go, or it's up to you to even assign your right to PRS or CMO to collect royalties on your behalf. It's all about you. In fact, there's even a new music business industry we call promote and later think of money. So people think that, no, they don't want to ask for royalties anywhere. Please use my song, share. Just use. If you make CDs and sell, and when I become big, like you are saying, Whiskey is big, then I want endorsement deals. I want to be on a product that will bring me money. And that is how people are thinking. So if you're an artist, for an emerging or upcoming or whatever, underground or whatever, I see you as an artist. All you need to do is to make sure that your target audience understand what you're doing and communicate to them how you want them to also take you for that purpose. Because we've heard about Ed Sheeran. He had no producer. He had nothing. He, with his guitar, he was playing on Facebook. He was playing on the digital platforms. And he became big. They're getting money. And that is how industry works. It's an individual affair. Somebody's car will be missing and he will decide not to make any noise about it. Somebody's car will be missing and the whole world will know. that my car has been stolen. Right. So this is how time will allow me. This is Bnoskka IP Zone, brought to you by Uprise Music. Uprise Music does distribution and publishing. And this is episode 18. And I'm so happy that you all came. I'm telling you, wonderful. We'll meet again. Subscribe, share, and follow. This is Bnoskka. Thank you.